So, about me, my name is Kalle Varisvirta. I'm the technology director at Exove. We work mostly here in Finland. We're pretty close from this place right now. And I'm not a lawyer, so even though I'm talking about a legislation, you need to remember that if you seek legal advice, seek that from a lawyer. They know more about the actual law stuff than I do. And also what kind of needs to be reminded that what I'm talking about here is in flux constantly, so we don't necessarily have the final answer on everything yet. Or probably for most things we don't have the final answer yet. So we need to, this thing is going to evolve until it's in force and until there's the first legal proceedings done against it or with it. I've been working with Drupal since 4.7, so I have some background with Drupal. The point of view here, I'm going to try and keep the point of view away from the controller position, which is controller is the company kind of who maintains or defines the purpose of processing personal data. This means that if you're a Drupal vendor, it's your client, which is the controller. Now, processors of data, however, are the people who technically can access the data. We're going to talk about that a bit more as well. I'm trying to keep the point of view in the presentation from a kind of a processor point of view, even though I touch a lot of subjects here still. We're not going to go into how the officials are going to be defined or what kind of new official parties there will be in the future. In the presentation, overview of the GDPR and then Drupal or other web platforms and the GDPR. Yeah, let's go to the thing. So what I'm talking about here is the General Data Protection Regulation. That's not its name. Its name is Regulation 2016/679 on the protection of natural persons with regard to the processing of personal data and the free movement of such data and repealing Directive 95/46/EC. We can also use the official name, but it's going to make the presentation about 1.5 hours long. We'll just stick to the short version. You can read it in that URL, so it's free for everyone to read and really take in. It's about, I think it depends on how you view it, but it's about 100 pages long. So we're going to GDPR. It's the new regulation. What's the old regulation? So we've had a directive since 1995 called the Directive 95/46/EC, and it's from 1995, and the world has changed quite a bit from that point. So there was a need to modernize it, but also unify it. Now, directives work in a way that all the member states will then fulfill the requirements of the directive with local legislation. So you will have a local law that follows the directive a lot or a bit less. It depends on the member states. There was a clear need to unify that. Is the mic not working properly, by the way? Do I lose my sound every once in a while? No?
No, sounds fine.
Okay. First row says sounds fine. So. Okay. Okay, let's try. See if it does it again, and then I'll switch to the other mic. GDPR is a regulation, not a directive. So that's something that becomes a law automatically in all member states. So there will be no GDPR local legislation, but there will be a lot of local legislation that takes GDPR into account. GDPR itself is the local law. So we need changes to, to 400 different points in the Finnish legal system to accommodate the GDPR or something like that. It's a lot anyway. So there are going to be changes to the local laws as well. But GDPR as itself will be law in all member states. And so when, well, I've seen some blog posts that don't really have this information correct, but the regulation was adopted last year, and it's currently in its 2-year transition period. So we're currently in the transition period, and next year, May 2018, it will be in full force. So there's no transition period after that point. And then we will have to follow it. Details of the regulation by the Commission, like guidance on how to interpret it and stuff like that. There should be stuff coming towards the end of 2017. Some local legislation might be as late as May 2018. That's pretty typical with these kind of things. And there also is going to be at least in Finland, the first suggestion as a law will be out at the end of this month. So we'll be eager to see how that fares here in Finland. So we know what the regulation is, and we don't have a lot of idea how to interpret it. And we don't have any idea how the member states will accommodate their local laws around it. And this is kind of to give you the idea, the level of trust you can have on whatever is said about the GDPR today. So we will, we all will know more as we go towards 2018. There's also a group called Article 29 Working Party that has a member from the EC and has some other expert members, and they release statements on how to interpret the GDPR. They also claim that that's not an official interpretation, and at the same time, that's the only interpretation we probably will get. So at least the lawyers I've been talking to say that that's how we will have to do interpretations on that. So the courts will use that as basis for that. So what's new? I think first of all, I need to say that not a lot is new. The GDPR doesn't have that much new things as you would expect. There's a lot of things that are already existing through the 95 directive. But what is new in GDPR is responsibilities for the processors this definitely doesn't work. Let's try this one. So what's new is the responsibilities for the processors of data. So if you're a Drupal vendor and you're offering support and maintenance to your Drupal site, you will be a processor, and you will have requirements coming directly from the GDPR to you. So you can't hide behind your client anymore. Currently you can. In the 95 directive, at least through Finnish legislation, the processors have only the liabilities you have in your contracts. So nothing coming directly from the law. And as comes responsibility, so comes administrative fines. So the fines will come also to the processors of data. There's a bunch of technically tricky items in the GDPR, I think, to target specific new services, I think. But as I said, really not a lot is new. Yeah, I think the key here is, why do you need to pay attention? If we had like requirements in the 95 directive, why is it today different? Well, it's this thing here. And a lot of our clients have noticed, definitely, the fines, because the fines are very high compared to anything we've gotten used to, I think, in the EU realm. So the infringements, the GDPR defines which clauses, you get different fines for, and this is the maximum one, 20 million euros or up to 4% of the total worldwide annual turnover. Which one is bigger? That's what you're going to get. So not what's smaller. And for some of our clients, that might be 100 million or a billion or something like that. It might be a lot. And now that these fines are coming in, at least our clients and your clients, if you're Drupal vendors, will add at least some responsibility on you to your contracts. They can do that. So be careful on what you sign. So if you have an innocent looking contract annex coming called Data Protection Annex, read it very carefully. What it says about fines coming through the GDPR and who's going to pay for them. So there's a broader definition of personal data. In the GDPR, it's pretty much as broad as you can get. So any information concerning an identified or identifiable natural person, an EU citizen, that is. So if you're offering service from outside the EU to EU citizens, you still have to consider that under GDPR. How are they going to enforce it? We don't know, but that's how it goes. And any data that can be reversed to identifiable with additional data. And there's an example IP address that is considered personal data through the GDPR because of this clause, because there is a way to connect that to a person. Otherwise, you wouldn't get sued for distributing illegal content on the internet. That's proof that you can get it reversed. And so if your Drupal site doesn't have your users, but you only store the sessions of the SSO service somewhere else, you don't get home free. So anything that's connected to that session hash, because that can be connected to the SSO service to a natural person, will be considered personal data. There are tighter conditions for consent, and this is going to be interesting because these are a bit contradictory, in my opinion. But it needs to be a clear affirmative act, specific and unambiguous, and covering all purposes at once. No pre-ticked boxes, can't happen from inaction. So you need to tick that box that your data can be processed and can be reversed at any time if it's based on consent. Now you can process data under GDPR also with other legal grounds than consent. But consent is the one that we see quite a lot these days online. And you need to keep a record of the active consent, that you can show that this person has, consented to the usage of the service, and you can't just say that because he registered, he probably, needed to do that, but you just have to have some kind of a row about that somewhere. And you can't require consent just because your service would work without processing personal data, but just because you finance it by processing personal data. This is going to be interesting how to see how it's going to affect the big ones. Also, they say that it needs to be non-intrusive, and if you look at the list here, that's what I'm really eager to see. How can you have a really good, nice experience of consenting to processing personal data without it being intrusive? it's definitely going to be intrusive in some way. But we'll see how that will be interpreted. And as it says, it needs to be specific, so it can't be within all your other terms and services, but you need to have that consent separately, because you can not consent on that separately. So the privacy policy, now significantly more controlled. All the data has to have a storage time or a criteria on how it's set, how long will you process data, because you need to tell if it's for the duration of the contract that you are entering into, then that's fine, that's a period of time, even though it would be a long time. But if it's for anything else, you need to say how long are you going to process the data. All the automatic decision makings, you need to explain them. This is for when they have significant influence over to the data subject. This is for instance, if you apply for a loan online and you do automatic checkups for that, you need to explain how that works, and also the end user can resist that, and then you have to do it manually and stuff like that. And you also need this for the third-party data. So if you have personal data coming in from somewhere else and not from the actual users themselves, you buy personal data from someone else, you need to have a privacy policy explaining on how you're going to process it. I don't know how the end users will find it, but that's what you need to have. So the privacy policy needs to have details of the controller, purpose of processing, recipients of personal data, details of transfers outside EEA or the approved EC countries, retention period or criteria on how set, all the rights explained to access, rectify, erase, and possibly port data, and that the consent can be withdrawn if it's based on consent, and if there's any automatic decision making, and some other legal details. But you get the idea. So the data subjects have access. They have to have access to the data. So that this is as before. We've seen this being implemented as, you send a postcard to the office and you get that paper version of that. And in the UK, they have even charged for this. Now, the first copy needs to be free of charge, and if you ask it for electronically, you need to get it electronically. So you need to get it in an electronic format. So you're not allowed to anymore require people to come locally to your headquarters and get it on paper, as has been happening before. And then there's a time limit for that. That's 1 month, but there are some exceptions. Then there's the restricting processing. If a data subject suspects that you're doing some foul play with their data, they can restrict processing on it. So you can't process it at all. And essentially this means, as a technical person, I just see that you need to temporarily remove it from the system, because you can't restrict processing. If it's in the system, it's going to get processed. You will not program any functionality that will just skip certain rows in your database. You will just remove it and then put it back in. And the regulation specifically allows this to be fulfilled by temporary removal of data. Then there's the portability, which is new. Now, the data subjects have the right to have their data ported in a commonly used machine-readable format. It's going to be interesting to see how that's going to happen, because for a lot of data currently out there, there are no commonly used formats. They're just all proprietary. And this only applies to data which he or she has provided to a controller. Now, and whatever you give out can't violate the rights of others. So if it's a group photo of a lot of people, you don't have to give that out, because that's violating the rights of others. But the idea is clear, so that you can switch between service providers to the next one. Now, there was a lot of questions about what does it mean that the data subject has provided that data. Now, there was the text came out this spring from the Article 29 Working Party saying that also when they are generated by and collected from the activities of user by virtue of the use of the service or the device. And this was interesting to the activity risks, the risk things you see, like all the watches and stuff that track your activity, because the GDPR kind of said that give stuff that you give out, and are you giving it out when you're moving your wrist? Okay.
I think it might be when you hold it from the below.
Okay, let's try and hold it from here. Yeah. Anyway, so the activity trackers, I talked to 2 activity tracker manufacturers, and they said that there is no common format, and the raw data of movement in your wrist will stay in that watch. They will never get it out there because it's only staying there for a couple of hours, and they just calculate it locally to activity data, which they then export. And they have their ways of calculating that activity data, which is different between different vendors. And this is the thing, really. We don't see how this is going to fly. But I'll just say that don't expect to be able to move from Fitbit to Polar next spring. You probably won't. You don't get your history data from Fitbit in that format, even though that's probably the idea of this clause. We'll see how it develops when we go towards commonly used data. I think it's a good idea, but then you can object if the data is processed for profiling. You can object to it, and I'm not really sure what this means, but at least for automatic decision making, you can object it being done automatically, so that if they deny you of credit online, you can say that I want this handled by a person. Now, the outcome will probably be the same, unless you know for a fact that there's a certain thing that the machine doesn't know that the person will. I think it's fair. Machines have a tendency to make the same mistake over and over again. Then there's the erasure. So data subjects have the right to get their data removed permanently from the system. If it's an online service, you need to be able to do that via electronic means. Controller should take reasonable steps to get that data, links to it, copies or replications removed that are out of their hands. But whatever's in their hands, they need to remove. And removal should be done without undue delay again. And also you need to remove it when there's no need for processing it anymore. You can't just store personal data just to be safe. What the EU Commission is probably visioning is some kind of a self-service platform where you can just request your data to be removed. Well, we have that for big online services, but the smaller ones will need to be done in a different manner. Then there's the data breach thing. Some people have a lot of focus on this. It's not a... Oh.
Will this make possible that it's finally possible to erase all Facebook data?
Will this mean that we can finally erase all Facebook data? Well, yeah, it does mean that. You should be able to do that, and they need to show that they complied to the authorities. Anyway.
How could they show that?
Well, the GDPR requires them to show that they are compliant, and not by the authorities to check whether they are, which is different from the current legislation. So currently, in the directive, it's the authorities' burden to make sure everybody follows the law. In GDPR, you need to be able to show that you follow the law. I'm not sure how that's going to happen. If you think about so am I going to get free access to the server room? Probably not. Just saying.
I was wondering, do they send you some sort of a document that
They will probably send you a document describing their process of removal of data. That's what I would expect, which then deems it, good enough. Anyway, data breach controllers need to inform the authorities within 72 hours of a breach, and the authorities may force the controllers to inform the data subjects in question. So this is different now. For processors, I don't see a big of a difference to the current situation. If you see a data breach in your client's system, you will inform your client immediately as before. I think nobody would sit on that information, would they? Well, at least I hope not. Anyway, so 72 hours, you need to assist, as a processor, you need to assist the controller on, finding out what has happened and all the details of it. And this, in non-compliance in this can lead to 10 million in administrative fines, or 2% of your global turnover, whichever is bigger. But I think it's essential to understand that it's 72 hours from when it's noticed, not from when it's happened. So I've heard people saying that, so we need to track everything that happens so that we can notice within 72 hours that someone has access to our network. Well, no, you don't need to do that. You need to just inform when you know, 72 hours from that point, to the authorities. Doesn't mean that you need to spy on everyone now, because, I've seen this, like, really scary stuff, guys. Really, really. Oh. Okay. Governance. You need to do with certain. If you have a high risk to the freedoms of natural persons and blah blah blah, you need to do a DPIA according to GDPR. If you have done privacy impact assessment documents before, it's similar. I think it doesn't. The GDPR doesn't dictate on the format of that, but that's basically how it's supposed to work, so that you just have a privacy impact assessment document done for the service. I don't see a harm doing it because it's not that burdensome, but that's in specific situations. Then there's the PIA or the DPIA. Article 29 Working Party has again released a long list of detailed situations when you need a DPIA. So read it from there if you feel like we might pose a risk to the well-being of natural persons here. Then there's the data privacy officer. You need to appoint if the controllers or processors' core activities require regular and systematic monitoring of data subjects on a large scale, or consist of processing on a large scale of special categories of data. And special categories of data has been defined in the regulation, and they can be extended locally. So, for instance, health data, union membership, race, religion, stuff like that. Those are all special categories of data. If you process them in a large scale, for instance, if it's a membership registry of a union, that means that it needs to have a data privacy officer. You need to do the DPIAs and stuff. Also, you need to have records of processing activities in written format. You need to have some kind of a log of what have you been doing with the data. There's an exception that if your organization employs fewer people than 250, you don't need to do it unless there's a high risk for rights and freedoms of data subjects. So we're at a bit less than 100, so I don't know whether we need to do these record of processing activities or not. Most of our clients will.
Yeah, wouldn't it matter what type of clients you have?
It definitely matters what type of clients you have. If you again work with a union or work with say a private hospital, that data, whenever you process there you will need to have that records of processing activity. So that process needs to be built into our workflow as well. So you need to log down what have you touched and why, when.
Do you need a data privacy officer when have clients, that you process clients' data that is really sensitive.
Okay, I was wondering about this as well, and that do you need a data privacy officer if your clients process a large quantities of, well, I would think that if it's not your core duty to process that data, and it's more like just to maintain the system where the data can be processed, then maybe not.
50-50.
Yeah. Take a bet. When you get the fine of 20 million, then you know that you should have. It's simple as that. Then there's the privacy by design clause, data protection by design, and data protection by default, as they say in the GDPR. That's a loosely defined concept. No real information on what that actually means. And again, I think we just need to think about this stuff when we do the systems. And this is data protection by design. Then there are the transfers, which are currently also banned in the current regulation, even though we do those transfers and we don't care because there are no fines. Right? We all do that, right? Mm-hmm. Yeah. So this time you will get fined if you get caught doing that. Safe Harbor is now replaced with Privacy Shield, and Trump hasn't yet messed it up. So that's, ooh, yeah. I don't know what next week brings. So you can still put your stuff to the US. Yeah. And as I said about the administrative fines, yeah. Going a bit faster forward because I'm lagging behind in time. Processor duties, you need written instructions from the controller on how to process the data, and you can't do any processing outside of that. So even it would be interesting to see how many people with a certain condition you have in your Drupal database. You're not allowed to do that, just out of fun. Sub-processing only by written permission. But this is probably in your contracts already now, so you can't do subcontracting without a permission. Assessing in controller compliance, and you need to allow audits by your client or someone else. This is, for this particular thing, you need to allow it. You can't. There's no way you can say that you're not allowed to audit. And then you need to show sufficient guarantees for compliance. Yeah. So, frequently asked question. We had a lengthy talk about this in DrupalCamp Baltics. I was doing the presentation similar to this. Am I a processor? Processor means a natural or legal person, public authority, agency, or other body which processes personal data on behalf of the controller. If you have access to your client's personal data, you're a processor. Simple as that. So, as I said, it's coming in, going forward, Drupal and the GDPR. Looking at Drupal, you need to remember the broader definition of personal data. So essentially, any data you connect to a person in your Drupal installation is personal data. And a lot of things in Drupal connects to the UID, that's the actor. And remember, all the maintainers of the site are covered with the GDPR, not just the users of the site, not just the end users, also the maintainers. If you have your maintainers, 5 people maintaining the site, their data is also covered by the GDPR. So not the users table, but maybe a couple more which might have data regarding that. Obviously, if you're just removing data, you can just empty all the stuff in the users table that point to a specific person. If there's if you remove the name and the email address and everything from the actual user, then it doesn't matter how many times it's connected anywhere because it's not any more connected to that person. So you can just kill it at some point. And another thing that I think is important, and I've been talking about this for a bit, is documentation and reality. Because if you look at an architecture of how a website and a CRM storage is connected, it might look something like this on paper. And you know it looks something like this, actually. It does really have that website and then the CRM. But it has a lot of stuff around it and next to it and between it and all that. And you might have a development environment, you might have a staging environment. Servers are cheap, they're not real even anymore. So you might have like 28 servers running for that single site. And you have your data, spread on all of those. So the privacy policies, as well as PIAs, are usually based on that first image, not the second one. So in the privacy impact assessment, if you participate, make sure that you tell how it really goes, how the data really goes in the system. And I think we automatically simplify complex concepts because we want people to understand what we're talking about. If we start by talking about really complex stuff to a non-technical person, they just don't understand what we're talking about. So let's just look at this briefly and see where can we find personal data. Can we find some in the varnish logs, CDN configurations, IP numbers maybe, web server logs, Drupal logs, local caches. There are uploaded binary files like photos of the people, or just binary files they uploaded because that's connected to them. It's still personal data. Mail log of the email sent. It has email addresses, backups of the servers. There's stuff on your MySQL servers, MySQL logs, binary logs. If you have a replica set or a replicated MySQL, backups of those binary logs, database dumps developers make. How many on your desktop right now? You feel the burn? Yeah, it's there. There's like a bunch of personal data on your laptop right now. Production dumps from staging environment or to staging environment. There's the integration platform logs, whatever, all the SaaS services that you might use that are located wherever because you don't care. It's just really handy to put that all the logs to that logging service online. And then there's finally the data that's in the CRM and the backup system maybe of that. So, this is your turf. This is your realm. And if you need to find the data, gather it, show it in electronic format, make sure you store it only for the retention period, and that you can really remove it fully from that setup. It's going to be complicated. There's the thing about the electronic format. There are requirements of providing stuff in electronic format. Most Drupal architectures, as any architectures, are optimized to spread out the data, to optimize the system, not gathering personal data. So they don't store it in a single place. So you need to be gathering it to a single electronic format. And you probably need to do some, at least partial automation for that, because you will come around to the situation where you need to gather it for a person. This is what your client expects, by the way. This is Google's privacy panel where you can just download a zip package of everything. At least they claim it's everything. Download your data there. Just do whatever Google does. They probably didn't spend a lot of money doing this. So, what to do? Take the regulations seriously. Map out your systems, understand what are you maintaining currently, or if you have your own system, what do you have? Consider the data flow, consider the cloud services, consider residual data that gets left behind when you remove stuff. For compliance, make sure your technical staff, if you're the technical staff, make sure your voice is heard. It's not a hobby project of the legal department in corporations. It shouldn't be. It's going to be a detached process if it's done like that. And if you're a Drupal vendor, make sure you protect yourself by contracts. This regulation has heavy fines and heavy requirements, and you need to protect yourself.
I just wanted to say that the contracts, when you like go into a contract, but you happen to do something that is not in the contract for whatever reason. For instance, you make a new feature, but you forget to agree with it with the client beforehand. Then you become liable for the full extent of the law.
Well, I think we're probably all going to do contracts where the client allows us to create new features on the site and process personal data based on that. But we need to explain what kind of processing we will do in the privacy policy to the end users. So yes, you need to be careful whenever you touch personal data. This is the whole legislation is designed for you to care when you touch personal data. And I think that's it. Almost went over time, but not still quite. Any more questions? Yeah.
You said about consent, but
Yeah.
explicit consent. So for the consent, if you already have people who are like signed up on your site, you need to get new consent from them.
I have no clue. I'm just going to be open and honest with you. I have no idea. I'm pretty sure you have to update your privacy policy and your terms and service, and then you need to get a new consent based on those. I'm pretty sure of that, but that's again the lawyer's turf. Any other questions you have?
I have a low-level Drupal question. For instance, if we need to pseudo-anonymize data, how would we go about it? Would we have like a separate website that is in a secure environment that keeps an eye that Janne is actually XP31 and so on? Well, or something like that. Well,
if your site can work so that you don't need it handy, because obviously if you have a site that needs that personal data carried out always, well, we've done we did a recently Commerce 2 site that has a React front on it, and we needed to touch health data, unfortunately, in that project. So we made absolutely certain that we only get that fetched to the React app and show it to the client and never store it to Drupal because we didn't want it there. So you have your ways of protecting your rights. Just make sure that you don't store data that you know that you don't want to store. But for that question, I think there are in large environments, for instance, if you have an SSO service that you use, like single sign-on service that you use for logging in, then you might just have that session that's connected to that data. But you will still have a lot of that data, and if that data somehow contains anything identifiable still, for instance, in one platform that we have that has a corporate-wide SSO, so we don't have the actual end users, we still have their IP numbers for a specific purpose. And that means that we try to keep it out and pseudonymize that specific data, but it might not be possible in a way. And I also think that whole concept of keeping identifiable data out, I think it's probably not going to fly as easy as I think the EC even thought it will.
I just wanted to quote that like the processing thing and the storage like isn't meant to be separate. Like when you process stuff, even if you don't store it, like all the terms still apply. Like because when you like in your processing you get a data leakage, even if you don't store it over there, but as long as you process it, like all the stuff applies still. So just to make that point.
Yeah. I understood that if you
with the SSO, for example, if there's some leakage because you're using a shitty SSO provider, then like
obviously it'll apply. And also, us processing data in a React app, we'll still be processing, but we'll be processing it very briefly, and it also, the funny thing is about GDPR is that it doesn't concern things on paper for some reason. It only applies to digital stuff. Yes.
Yes, when you kind of give the end user access to download the data, does this only apply to the data that you actually have in your systems, or do you also have to download everything that can be backtracked to the other systems by your kind of data that can be linked? So do you have to?
Well, if you have that data, that's what you need to provide.
If it's accessible.
Yeah, if you have
from
it.
your end, yeah.
Yeah, you don't have to connect it to. If you have a phone number, you don't have to connect it to an address because that's in the phone book. It's that's outside your. You just need to.
Kind of own it then.
Yeah, but it's just the connection thing is just meant to make sure that you have. You understand what is personal data. So if you have a phone number, it's still personal data because it can be connected to a person and stuff like that, as well as the home address. Anything else? Oh, there's a question there.
Yes, I was thinking about that detail about the IP addresses.
Mm.
If I register in some service and after that hack in their database and do some illegal stuff there, and after that I send demand to service provider that I want them to remove all my stuff, including IP addresses. So how they can connect my acts.
Well, your right for erasure is based on that either it's based on consent that you remove your consent of processing, or there are the legal grounds for processing it is ended, so your contract is ended. Then you can or they should remove it anyway. So it's based on consent. If they have any other legal grounds to keep your data, they don't have to comply with that.
And security is one of those reasons. So
Yeah.
web server access logs are exempt from that requirement.
For instance, web server access logs, you need to tell that you have that data. You need to show that data even, but you don't have to remove it if it's part of your security system. And there are a lot of situations where you don't have to remove the data, but you need to be able to provide and show what you have, but you don't have to remove it.
But what about web application database and logs where IP address logs?
If you have defined it beforehand as part of that you process it based on legal grounds for security, then you don't have to remove them, so you can't store them. You still need to have some kind of retention period that's in some correlation with something, but for a lot of things, we did a GDPR consulting gig with our client that had a registry of people who have abused their systems before, and the lawyers that we partner with said that you have a clear you have a clear legal reason to keep that data. You don't have to remove it. It's for protecting others, for instance. So there are ways to keep it. Okay, thank you.